Yes, we can start now.
A very good afternoon to all, and thank you for joining us for eJurist Day on Statutory and Regulatory Structure of Online Contract. It's a great honor to have with us Dr. Risham Garg, Associate Professor of Law and Research Director, Center of Transnational Commercial Law, CTCL, NLU Delhi. I, Dr. Swati Srivastav, take this opportunity to welcome you all on the behalf of Center of Legal Studies, Geeta Ratan International Business School. The institute is aggregated as Category A by National Assessment and Aggregation Council (NAC) and assessed as Category A+ by State Fee Regulatory Committee and rated highest grading A by Joint Inspection Committee of Government of NCT of Delhi and GGSIP University. The institute has been graded A by Academic Audit Cell of GGSIP University consecutively from past 6 years. GIBS has also been rated number 2 twice by Times B School Survey 2019-20. The Industry Institute Partnership Cell IIPC of GIBS has introduced Jurist Day as a platform to give practical knowledge of legal sector to our law students. On Jurist Day, we invite eminent legal experts to talk on legal issues of importance. The theme of this Jurist Day is Statutory and Regulatory Structure of Online Contract. We at Center of Legal Studies GIBS understand that navigating the pace of change, dealing with immediate issues can only be developed through taking regular insight of problem with an opinion of experts. E-contract is any sort of agreement shaped over a span of web-based business by connection of at least 2 people utilizing electronic means, for example, a computer program, or the communication of no less than 2 electronic operators that are modified to perceive the presence of an agreement. So this is how the topic is going to be highlighted in this particular session. The objective is to help students understand the validity of e-contract, to appraise them with the regulating rules and provision under the ICA and IT Act, to inform them about various forms of e-contract. The Jurist Day is aimed to appraise students with the underlying reasoning behind the validity of e-contract and further analyze the rules and provisions under the Indian Contract Act and Information Technology Act, and finally inform students on the various forms of e-contract. We are honored to have our session chair with us, Dr. Risham Garg. He holds a Doctor of Law, LLG doctoral research degree for his work on international contract and the UNCISD Convention. He presently teaches course of Transnational Commercial Laws, Bankruptcy, Insolvency and Reconstructing, Law of Contract, Sales of Goods, Private International Law in the postgraduate and undergraduate law degree program. He had previously taught paper of law of property, banking law, and negotiable instruments, international commercial arbitration, law of tort and consumer protection, legal and constitutional history, and legal methods. He is also the research director of the Center of Transnational Commercial Law, CTCL at NLU Delhi. He's continuing with the NLU Delhi as a regular faculty member since 2009. He has previously worked as a lecturer at Amity Law School, IP University Delhi for over 6 years. He has been a visiting faculty at NLU University Orissa, Cuttack, the Indian Law Institute, Amity Business School, Noida. He has also acted as a consultant to the Director of Legal Education of Bar Council of India. He acted as arbitration at the William C. International Commercial Arbitration Moot on the international sales of goods CISD convention at Vienna and at Hong Kong, and also at the Indian round of widespread moot. I would request you to enlighten our students with your knowledge, sir. Welcome you, sir.
Thank you, Dr. Swati, and thank you for the Geeta Ratan Business School, International Law Society, the law school, and I am very much glad to address the young minds of this eminent school. So I have been invited very graciously to share my views upon a topic on contract, and the topic is statutory and regulatory structure of online contracts. I would have preferred if I can have a look at the students also, but I'm not sure how is it possible. And I just wanted to have one more maybe question to Dr. Swati. Is there a possibility of me interacting with the students, like if they want to ask questions? How is it possible?
Sir, it's through chat. Through chat it is possible, sir.
Okay. Right. So I'll start my presentation, and intermittently I will also ask you if you have some questions, and then I will take pause at certain places. Right. So before understanding the basis of the regulatory aspects of online contracts, we need to know certain basic contract law principles. What is the basis of contract law principle? So all over, it's like globally recognized that we can consider three contract law principles. There is a freedom of contract of parties, laissez-faire. Then there is equality of bargaining power, and through the equality of bargaining power, we also understand the equality of bargaining power, that is the intensity of need of the parties for exchange of economic resources, and the level of information of market forces of the parties. So, this is the contract. Even though we may consider economically the parties may be in a different position, there may be one industrialist, and against the industrialist, there may be a small scale producer of, let's say, cartons. There may be a carton manufacturing business, and it may be a SME, small and medium enterprise. So maybe economically there is a disparity. However, the contract law presumes that both are in equal bargaining power. That is, that neither of the parties should be able to exercise any influence over the other to enter into the contract. So there needs to be a free will or freedom in the minds of the parties to enter into the contract. Then there is a symmetry of information of market forces, that because they need to determine the price of the product, they need to bargain, they need to negotiate. So you can enter into a bargain, you can negotiate when you have information about the market forces, and it is assumed that all the market determinants or the symmetry or such information will be available to the participants or the parties who are entering into the contract. So, you have started reading contract. What is contract, and how do we understand the Contract Act? So you read from the Indian Contract Act of 1872, and what do we understand by reading this act? So this act can be, divided into two parts. First part can be considered to be the general principles of contract law, which is from sections 1 to 75. So this is contract formation principles, contract discharge principles, and then some other principles. After 75 are the specific contracts. So you will read, whenever you read an act or a bare act, please remember that there are certain headings, chapters in which the act is divided. So it will be very interesting for you to read through what are the names of those chapters or those headings. So when you read the chapters after section 75, those relate to specific contracts. So what this means is that from 1 to 75, these general principles of contract apply to all of the contract law or all of the different type of contracts which are entered into India. After section 75, these are specific examples, for example, indemnity, guarantee, bailment, pledge, agency. And at the time when the act was enacted in 1872, partnership and sale of goods were also a part of the act. But they were specific contracts, and it was found appropriate to siphon them off in separate independent acts. Now, before moving on to some provisions and definitions, let's again consider, I'm sure I've been told that you have been informed certain theoretical aspects of contract. So I'm sure you will be able to relate to some of these principles as well. So legal regulation by private legislation creates rights and duties. So individuals enter into contracts, there is freedom of contract, but private legislation, maybe Contract Act, then there can be other legislations, transfer of property for immovable property. There can be other legislations which regulate that choice. Similarly, age of majority. So you read in the Contract Act that any person who is entering into a contract must be of the age of majority. But where is the age of majority provided? It's not in the Contract Act. You find it in a different legislation. Then there is a direct interface with economic system. Whatever is the type of economic system that we have, let us say in India, we have a market-based economy. You may hear some countries as a capitalist model, some countries as a socialist model. So there is a direct interface with the economic system. So the contract law also determines the type of economic system that we have, and accordingly, the law provides those type of rights or the regulation to the parties. Method of learning has to be different than general. And then again, a very interesting aspect, the contract legal language. Legal is. So, you must have heard about legal is. Whether it is essential, well, you might have heard, you might have seen contract clauses being drafted in very typical language, which is called as legalese. Previously, it used to be very charming that yes, it's so technical and so legalese that it's of a high quality. But what is required is that contracts are required to be understood for business parties, for business purpose. They may be entered into by lawyers or legal experts, but businesses may not always, require to go to the lawyers or legal experts to be able to interpret the contracts. So contract legal language needs to be simple so that it can be understood by a common person. You need not to be a lawyer to understand. There are so many businesses, so many common people, and they just want that it has to be into a simple language which they can easily understand. And in a country like India, where there are a huge number of businesses and industries who are not, of a big size. They are SME, small and medium enterprise, or MSME, medium and small enterprise, or average sized. So they need to keep their costs low. And if the legal costs are low, they can utilize their economies of scale for their business. So this is all very essential. Why do we need contract? Well, we need contract to support the ecosystem. Other laws, public law creates rights and duties, not to direct interface with economic system, general method of learning, and to what extent it is important. Well, now I have mentioned here whether there is a case for legalese or not. So I am constantly looking at if there is any question. If there is question, please write over here and I will constantly have a look at that. Now you have read in section 2, which is called as the interpretation clause or the definition clause. So there is in section 2A, you read the definition of proposal. Then there is a promise. And then you read in section 2G, what is a contract? So section H is an agreement enforceable by law is a contract. Section G says an agreement not enforceable by law is said to be void. So there are certain void agreements, but agreement enforceable by law is a contract. So what does this mean? This means that every contract is inherently an agreement. And what's an agreement? Agreement again goes back to promise. So ultimately what we have been able to identify is that there is a promise, and that promise needs to satisfy certain essentials, and then it can be considered to be an agreement. And if an agreement is enforceable at law, then that agreement can be considered to be a contract. So if there are any questions, please do write them, and if there is any issue regarding my audio or video, do let me know.
So there is a question from a student, Anurag Nahata. He wants to ask, are e-contract superseding traditional contract?
Right. So I'm reaching that issue about e-contracts.
And there is one more question from Vanshika, that what shall be the jurisdiction of the court under a contract?
All right. So that's interesting, you know. So this shows that you have been reading, and I really appreciate your questions. So let me first address the issue of e-contracts. So now Indian Contract Act, you know, was formed in 1872, and then you have been reading a few cases. Basically, you read the case of Bhagwan Das, Govardhan Das, Kedia, and in that case is a leading case where the instantaneous modes of communication was considered by the Supreme Court. And a leading British case of Entorse versus Miles Far East Corporation was also referred to. So generally in the Contract Act, there is a rule of postal rule that there needs to be an acceptance, and the acceptance, if it is sent, if it is posted, that concludes a contract. But this situation is not the same in the civil law countries. The civil law countries' contract law requires that the acceptance must be received. Now, in the case of instantaneous communication, for the first time it was decided that, you know, whenever there is an instantaneous mode of communication, it's not just sufficient that the acceptance is posted, but it's also required that the acceptance must reach the offerer or the addressee. So there needs to be a communication or the receipt rule. Now, when we are discussing the e-contracts, you know, so e-contracts can be of several types. I will just refer to you two basic type of contracts, one through email, that parties are negotiating the terms, they're entering into the contract through emails. And then secondly, the most popular form is when you are making purchases on internet, e-commerce websites. So purchasing on e-commerce websites is also e-contracting. Another form of e-contracts, as I have mentioned, contracting through emails. Now here the Information Technology Act principles are required. So, that is why when you read this
so there are, I'm sorry to interrupt, there are 2 or 3 questions from students. Should we take it at the end of session or in between?
No, please continue. Then I can, discuss accordingly.
Okay, so there is a question from Aditya Raj saying, in near future, won't it happen that the Information Technology Act 2000 might substitute the Indian Contract Act, especially in this era?
Okay, and
the next one is, what is the place of e-contract? Like if any case arises, just hold on, sir, I think it is gone.
Never mind, I understood it.
In case if any case arises, then which court will have the jurisdiction to try online contract dispute?
Okay, good. I I appreciate all your questions. Right. So okay. So now you know that. Okay. So first thing is the basic principles. I do appreciate your questions, but for the benefit of all, let's keep some sort of a sequence. So we discussed the basic principles of contract. So the Contract Act of 1872 provides for some contracts, and which basically we recognize the usual or the postal rule, but not the electronic contracts. So in the modern technology, it was felt that the Contract Act provisions are not able to satisfactorily address the issues of electronic contracts. Hence, the Information Technology Act of 2000 was enacted to provide for certain rules. So one of them, as I've also already mentioned to you, is that there must be a receipt. So in case of the contract is concluded when it is received. So it is a receipt rule. Now your question is which we can also say about conflict of laws. To regulate or govern the contract, now we have two acts. We have the Contract Act and we have the Information Technology Act. So the question naturally arises, which of the acts will be applicable? So this is the based upon the principles of conflict of laws, that wherever there is a possibility of application of 2 or more laws, the principles of conflict of law will apply, and some general principles of interpretation of contracts will also apply. So the general rule is specific will prevail over the general. So sometimes all are specific laws, but here we can easily understand that the Contract Act of 1872 is a general act and it generally applies. But where there is an issue about electronic contract or emails contract, it is a specific situation. So in the specific situation, the specific or the special act, which is the Information Technology Act, shall be applicable. So the contract will be governed by the Information Technology Act. Now, your next question is about the jurisdiction. Now, going back to the case of Girdhari Lal, so you must have read, the issue was where the contract was formed. So the basic issue that was debated in that case was where will be the jurisdiction of the court, whether it will be where the the parties were claiming that the contract is wherever the contract is concluded, that will be the place for the jurisdiction of the court. So please again listen to me carefully. The parties were arguing that the jurisdiction will be the place, ought to be the place where the contract is concluded. So one party was arguing that the place where the acceptance was posted, that should be the place where the contract is concluded, and hence the jurisdiction should be at that place. The other party was saying that, I made an offer at this particular place, so hence this should be the place where the contract should be deemed to be concluded, and hence the jurisdiction ought to lie there. However, we need to understand that when we are reading the classification of law, so there are different classification of law. You read classification of law, public law versus private law. So if I ask you what is public law, you will say constitution, administrative law, criminal law. They are basically the public laws, and nearly every other law is a private law. Contract law is private law. Then Companies Act and all of the commercial laws, they're all transfer property, they're all private laws. Another type of classification is procedural law versus the substantive law. So the substantive law provides the rights and obligations of the parties, whereas the procedural law provides how those rights may be enforceable through the courts. Now, the issue of jurisdiction is an issue which needs to be determined by applying the procedural law, not the substantive law. Contract law is substantive law. And hence, the arguments by the parties in Bhagwan Das case were not appropriate, because substantive law principles do not determine jurisdiction. Jurisdiction is determined basis the procedural law, which is the CPC. So applying the CPC or applying the jurisdictional procedural law in contracts, we can identify some principles which is basically recognized as cause of action in the CPC, the Code of Civil Procedure, that wherever the cause of action lies, the court can have jurisdiction. Or in some other non-legalistic terms, we can also use connecting factors. So cause of action may arise in different places. For example, one can be where the offer was made. Secondly, where the acceptance was given. Thirdly, assuming the buyer has his place of business, which is a factory, which is in a different city, and he requires the goods to be delivered there. So the place of delivery now is different from the place of office of the buyer. Similarly, for the seller also, seller may be having an office at a different place, but he may have a factory at a different place, which is dispatching the delivery of the goods. Apart from that, there may be another place, assuming the parties, that is buyer and seller. Buyer is from Bombay, seller is from, let us say, Shimla. They go to Delhi in trade fair, they meet in the trade fair, and they enter into a contract. So they are entering into a contract at a place which is not their usual place of business. So there can be any number of places where a cause of action can arise. So as far as the jurisdiction is concerned, well, wherever the cause of action arises, so out of these 5 or 6 different places, at any place, the cause of action can arise. And if a suit is filed at any such place, the court may determine that yes, a cause of action has arisen according to the facts and circumstances, and may assume the jurisdiction and may start the proceeding. So substantive law does not have a role to play for the jurisdiction, but yes, certainly the parties can contract, parties can provide a clause where they may agree that I want, let us say, as an example that I have just discussed, that there are involvement of 4 or 5 different places. So the buyer may say, well, my office is in Bombay, but my factory is in, let us say, Surat, and I want the jurisdiction should be in the courts of Bombay. The seller may agree or the seller may disagree. But if the buyer writes this type of a clause, it will be called as a jurisdictional clause. Now, there is also a rule for interpretation of such a jurisdictional clause, and that is that it needs to be exclusive jurisdictional clause. That is, the word exclusive must be mentioned, because if it is a general jurisdictional clause, if it is just says that the jurisdiction of the contract will be in the courts of Bombay, well, the court will not, agree, or court will not limit, or court will not say that, the party has mentioned Bombay as jurisdiction, but it is not exclusive jurisdiction, or it does not exclude any other place where there may be a cause of action. So there must be exclusive jurisdiction clause, or the jurisdiction clause must exclude all other places and provide jurisdiction to only one place. So this is in one way where we can understand the jurisdiction. Now, jurisdiction for the e-contracts. The difficulty is over the internet, how to identify the place where the contract was formed. Ultimately, you have to rely upon the usual place of business of the parties, or if you read in the on the e-commerce websites, so e-commerce websites will always have a clause which they will call as a which are called as the boilerplate clauses, and the boilerplate clauses have such clauses I have mentioned, the choice of law clause or the choice of court clause. So invariably, if you are purchasing on an e-commerce website, in the long list of terms and conditions, you will also find one term which is mentioned that any disputes in this contract will be adjudicated only through arbitration. This is the dispute resolution clause. Or it may say that any dispute in relation to this contract may be decided by the courts of Bombay only. So this means that the e-commerce website in its long list of terms and conditions is also providing you a jurisdiction clause. So generally a jurisdiction clause will be provided. If it is not provided, then as per the rules of cause of action in the Code of Civil Procedure, that will be determined. So this is in case of domestic transactions. Even in case of international transactions, there is no stopping. There are different rules for that, but certainly if the foreign company has a place of business in India, there must be some office, some individual. So wherever that individual is there, wherever the defendant resides, that would be the place of jurisdiction. So I think these were some of the questions that you had asked, and I believe I have addressed them satisfactorily. So if there are more questions, I would welcome them.
Yes, sir. There are 3 to 4 more questions from different students. So there are a lot of queries. The one is like a question from Priyanshu is, are there significant legal issues on face in signing a contract, e-contract? And the second one is, sir, according to 43A of Information Technology Act 2000, the sensitive personal data or information such as passwords, medical records, and history, financial information such as credit cards details, bank details, etc. Now, for today's situation, we can hear that somewhere WhatsApp new terms and conditions are violating Section 43A. So, as being a work citizen for the nation, what can we do apart from boycotting WhatsApp? Next Question is, what is the effect of mistake, mispresentation, and undue influence, respectively, on validity of an agreement? And so there's one question more. According to Information Technology Act 2000, that no specific provision is being made for the validity of online contract. Also, it cannot be challenged based on technical ground. If Information Technology Act 2000 does not guarantee people, then why in India it is applicable or even being used?
Thank you for those very interesting questions. I really appreciate interactive class, and I really appreciate your zest for learning and knowledge. So I'll start from the last question first. Now, as I mentioned to you, that the court will apply the law which is best suited to resolve that issue. It does not mean that only the IT Information Technology Act will apply or only the Contract Act will apply. So the reason for explaining the Indian Contract Act as the general principles of contract is that sections 1 to 75 will apply to all type of contracts and in all type of situations. What this means is that assuming that you have the Information Technology Act, so just assume that whatever, just barring the provisions which may be overlapping, for example, formation of contracts, offer acceptance, concluding of contract. So barring those provisions, all the other provisions of Contract Act of 1872, which is from section 1 to 75, will be deemed to be incorporated into the Information Technology Act of 2000. We have express provisions when you read the Transfer of Property Act, the Sale of Goods Act, and even the Information Technology Act, which states that the provisions of the Indian Contract Act of 1872, which are not inconsistent so far, will be incorporated into the issues or cases which are being covered under this act. So there is no, so that is why this is a ecosystem. The Contract Act of 1872, sections 1 to 75 are the general principles. And again, for the sake of repeating, they will be applicable to all the contracts, subject only to those sections which might be conflicting or which might be overlapping. So for the overlapping principles, overlapping provisions, sections, only the Special Act sections will be applicable. So I think this satisfactorily explains to you that if you feel that the principles of voidable contracts or factors vitiating consent like misrepresentation or undue influence are not present in the IT Act, that does not mean that the Contract Act will not apply. So Contract Act principles, factors, the section 10. So section 10 of the Contract Act, just consider that it is mandatory in every contract, right? So it will be applicable. So please read section 10, and those are essentials of a valid contract. So all of those essentials needs to be satisfied for all the contracts. And again, going back to a basic principle, basic element of contract, whether all contracts needs to be written or can unwritten or oral contracts be valid as well. So all contracts, whether oral or verbal, written, unwritten, can be valid subject to essentials mentioned in section 10 of the Indian Contract Act of 1872. So the principles or the factors vitiating consent will be applicable, will be incorporated into the Information Technology Act. Now, as far as the situation of Sorry, Dr. Swati, what was the first question that you mentioned?
Yeah, so is ADR dispute resolution method available for online birch? And then there was, sir, according to 43A of Information Technology Act 2000, the sensitive personal data, cards, all these he's talking about, password, medical records, and these all things on WhatsApp. So the new act which has come on WhatsApp is violating section 43A. So being a work citizen of this nation, what can we do apart from boycotting WhatsApp? And the next was, are the significant legal issues one face in signing e-contract?
Right. So first, let us take this issues on signing the e-contracts. And as far as the data privacy is concerned, so we have a data privacy bill. It is being discussed. There is a draft bill, and it will be enacted. But what we also need to know is that the Contract Act, basically visualizes commercial contracts. And again, you see an ecosystem in the Consumer Protection Act. So we have discussed the Contract Act of 1872. We have discussed the Information Technology Act. But there is also another act, which is the Consumer Protection Act, which is also applicable to contracts. All right. But contracts where one party is a consumer. So generally, in case of a commercial contract, there is a commercial transaction, there is a money issue, and the person is purchasing for money. So hence, the role of the state is of least intervention, right? So we read there the principle of freedom of contract. The state has a minimal intervention. But where one of the party is vulnerable party, that is a consumer is considered to be a vulnerable party, there the state provides a special legislation to protect, we can say that to protect the interest of the consumer, or to ensure that the interests or the legal rights of the vulnerable party are protected by the state. So the Consumer Protection Act provides those circumstances. Now, similarly, the issue of the data privacy, WhatsApp and all, you are entering, so contract, there has to be some monetary terms. There may be an agreement, you are utilizing the features of WhatsApp. It is all free, generally. I mean, apart from the Facebook or WhatsApp business account, generally it is free, and we are using those free features. It is, how can you say there is a binding contract? Because there is no money, there is no consideration. So you are willingly utilizing those software. You download several software over the internet which are free for use. There is a license policy, huge, big license policy, maybe running into 100 clauses or 10-20 pages, and nobody cares to read them. But we generally download and use those software. Can it be a contract? Well, there are terms and conditions, right? You have not paid anything, there is no consideration, so it cannot be a contract. And hence, because you have not paid consideration, they have requested, they have mentioned that they will access and store your data, usage data, and they may utilize it. So you are using a software or a service for free, and in exchange for consideration, you are giving them your data. So we, the consumer, we the people, should be careful that if we feel we are using anything for free, it's not free, because you are giving in return your valuable data. So there is no contract here. So because there is no contract, hence the government is stepping in to provide this personal data protection bill. So for several of such features like Facebook, WhatsApp, where people are using those services for free, but those software and services are collecting your valuable data. Now, there needs to be a mechanism to use and save and store that data as well. So because there is no contract, you have not paid any consideration, you do not have an action in the in a civil suit or in a contract. But certainly, the government certainly needs that there is valuable data, and they should prevent and they should regulate it. So this is now again the issue of regulation of the personal data of the people, which they are sharing for using certain software for which no money is paid. So hence, you in the same line, we have read the government banning certain Chinese apps, TikTok and so on, because several of those apps were also collecting several information of the party. So it's not only WhatsApp, it's not only Facebook, there are several issues, and it's good that you are asking these questions, because you should be aware and you should make your neighbors and friends also aware about the implications of using such software and free apps. There is nothing such as free. If you feel something is free, you are giving a lot in return to them, and you have not so if you do not take the precautions, people have paid a price. And because people are not so cautious and careful, the government is stepping in with that bill to ensure that whatever app or whichever service is storing or saving personal consumer or individual's data, there should be some system, some regulatory mechanism where it can be utilized. So I think there is now just one more question which was left regarding the main issues in e-contracts. And in case of again e-contracts, the main issues, as we have discussed, certainly first is that it needs to be an offer. There needs to be a proper mechanism, offer acceptance, and if there is offer, there is acceptance, contract will be concluded. Then whether there is any factor vitiating consent, whether there was any element of coercion or fraud or undue influence. And certainly if you are advising any person, you also need to ensure that there are sufficient safeguards. For example, the price of the goods, or the time of delivery, or the time of performance, or the method of performance. Or if now we have seen the time of COVID, people used to provide a force majeure clause or a clause of frustration, but they used to provide, let's say, natural calamity like flood or rains, but many of them did not provide for a pandemic. So if you provide for a pandemic, then the premium may rise. So I think the biggest takeaway from today's circumstance is that whenever you are entering into a contract, ensure that there is a force majeure or a frustration clause which provides for all type of maximum type of eventualities, which ought also to include a pandemic. So there can be several type of other factors, but if there are any specific questions, I would welcome them.
Yes, sir. There is a question, sir. As India is using electronic data interchange EDI system, which is for trading thought, it is safer than email. As there is low quality service and also there is less manpower availability in India for using EDI, is this appropriate that people to perform online contract on electronic data interchange? And there is one more question. So won't WhatsApp and other software come under shrink wrap agreement or under the web wrap agreement? And the third question is, what are the impact of Consumer Protection Act upon the law of contract with reference to the aims, objectives, scope, national regularity, institute, and sanctions.
Right. So the Consumer Protection Act issue I've already mentioned to you. So Consumer Protection Act recognizes that one of the parties to a contract is a vulnerable party, and the government has prepared a special law. So special law will override the general law. So wherever there is a consumer, the Consumer Protection Act will be applicable, and it is a more stringent law on the corporations, the companies, and the benefit of the Consumer Protection Act is that if any of the clauses, or which we can also say as the standard form contract, are found to be violative of the Consumer Protection Act, those clauses will not be applicable against the consumer. They will be waived away. So this is a complementary. These are all complementary laws: General Contract Act, then the IT Act, the Consumer Protection Act. These are all complementary laws. There is no, in some situations, there might be some overlapping, but when you actually apply, you will find them complementary. Now, as far as the issue of the way, society and technology continues to develop, there are n number of ways in which technology can be utilized. Even in case of contracts through email, smart contracts, there are various type of ways in which contracts are formed and enforced. Ultimately, what's required is that the people or the parties who are preparing this contract mechanism are able to adhere it to an existing regulatory regime. So even considering the smart contracts, they do fall under some sort of an existing regime. So there can be any technology, but that technology, it may be that at the time the technology is evolved, there is no law to cater to it. For example, in case of aggregator-based cab service, Uber, Ola, when they arrived, at that time probably there was no certain regulatory policy which could comprehensively govern them. Because if you considered the tort law, whether there is a master, there is a principal agent relationship, or there is a master servant relationship, well, there is no vicarious liability, because this way that we are just aggregator, we have no responsibility. So initially, there were issues, there were some criminal cases, there were tortious cases, and ultimately the government said, well, sorry, your the contract between the aggregator and the cab driver, we are not going to recognize it. Ultimately, the aggregator or the company, that is Uber, they will have to take the responsibility as being the principal. Similarly, in case of technology, there can be several type of technologies. In case there are payment technologies, there will be some regulations by the RBI, the central bank, which will be applicable. So in case of smart contracts, in case of, let's say, the GST, or even in case of the transport sector, generating of the invoice by the GSTN, so blockchain contract. So certainly there is some sort of a regulation which is there. So it depends upon the parties, their use of technology, to what extent they are comfortable, to what extent they want to keep it under the regulatory mechanism, and they need to ensure that it is as per the regulatory mechanism. Otherwise, you will face the problems. So certainly now we see that the technology is changing very fast, but there are regulations also which are there. So just don't stop at the Contract Act or the IT Act. You need to go further. look into the relevant RBI regulations. There will be some payment gateways, there will be some other infrastructure, some other regulations which will be created by some sectoral regulator. So, I mean, so first step is that you need to know that there is a substantive law, and then when you actually look at the problems, you look at how those problems can be characterized as an issue and how those issues can be resolved by applying the appropriate regulatory or the legal regime. So I really appreciate and your inquisitiveness and those questions, and yeah, this shows that you are all very, very energetic and bright young young fellows. Yeah, any other questions?
There is one more question, sir, from Ritik Ratan. Sir, Europe once filed a suit against Facebook, WhatsApp, and Instagram when these sites started storing some personal data. So why India don't take step like this? And in fact, these sites paid the fine to Europe around $1 billion.
Well, you have several questions. Again, Facebook. Again, the question is, we are the topic for today is legal and a statutory regime for contracts and e-contracts. And contract is possible where there is consideration. If there is no consideration, how can you find there is a contract? So in case of Facebook, how can you say there is a contract? But yes, there is. You yourself are sharing your valuable data, and to say it bluntly, people are not being careful enough, and they are saying that we are getting anything for free and we are going to use it. But the government says, it's a very sensitive data that you are sharing, and you should not be sharing it for free. Similarly, we have seen some predatory or the anti-competitive approach of some players like Google, Microsoft in some places, and maybe Facebook and WhatsApp and as well. So I this is not the topic for discussion now, but I appreciate that you read a lot, but I'll just probably draw your attention to the use of or the misuse of social media in the US presidential elections. The last presidential elections also, where Donald Trump had won, there was a claim of misuse and focused application of social media by the Russians to ensure that Donald Trump wins. And this is, when you read further, you will read that social media, Facebook, or if you visit any e-commerce site and you are browsing through certain goods, so those cookies, they get saved in your browser, and all of these social media sites, they have their algorithms, and their engines capture your browsing preferences, and basis that they provide you certain suggestions. So there are these algorithmic modules which are assessing the browsing history and the preferences of the people who are accessing these sites. So the knowledge of law is not sufficient. The knowledge of technology also is essential in the present times. So it doesn't just stop that the EU is acting against some social media websites, but you should also know how these social media can be used or abused or misused by different people or organizations or some countries as well. So even now, last week, what happened at the Capitol Hill in Washington, D.C., there was a unruly mob which laid siege over the parliament, where the Senate, where the votes were being counted. A lot were attributed to the social media, and that is why Twitter has suspended indefinitely the account of Donald Trump. certainly, this social media, this creates a mob frenzy, hysteria, and so on. And people should be, it's not, it's, again, I will say, there are a lot of issues, but every issue cannot be resolved through law only. There are some issues of media, there are some issues of society, and you need to characterize where the sanction lies. So maybe Twitter did not apply any legal means, but it said, all right, we know that you have abused and misused our forum by inciting violence amongst your supporters, so we suspend your account indefinitely. And they are left, they have given some maybe incentive or a suggestion, implicit suggestion to people that if you want, you can file a class action suit against these people, that because of their actions on social media, some people have been harmed or endangered and so on. So I think everybody is now gearing up. After Biden takes charge, they will proceed against Trump and all of those people who have used and abused social media to incite violence and so on. So there are different things, and certainly it's a great interest for you to read through those things. So I think I have discussed a lot of things in a very wide spectrum. But my suggestion and advice to you will be, please focus upon the basic law. So basic law, substantive law. If you have issue of substantive law, it will be resolved through substantive law. If you have issue of procedural law, it will be resolved through procedural law. If you have an issue of policy, that will be resolved through policy. Contract, again, essentials of contract, consideration must be there. There must be a contract offer acceptance, concluding the contract, and so on. So everything is not in a contract regime. Everything cannot also be resolved through law only. There are other modes. So I think
So the questions are coming up again and again, but I do understand, sir. So, sir, thank you for choosing us to be or giving your special time and with the students of BA LLB and BBA LLB. And it's an honor. It's really an honor for you to be with us and sharing your time. And I will definitely try that student next time whenever we do our session, we will have you with us, because still now the questions are coming, but due to shortage of time, I just want to propose a heartfelt thank to you for being here with us and with our students. Thank you, sir.
Thank you. Thank you, Dr. Srivastav, and I also thank Professor Hoti for inviting me to this lecture. And I really enjoyed all this interaction with the young minds, and I wish them all the best.
Thank you, sir. Thank you.
Thank you. Thank you.